Good day and welcome to another Paddocks Club video tutorial. One tries to look for new issues for tutorials, but an issue that comes up again and again in sectional title scheme management and therefore deserves, I think, repetition is the question, how can we change the basis upon which levies are charged? Sometimes the issue doesn't come up directly or in advance. It's not an abstract question that owners or trustees ask themselves. The trustees may, just when they see a new expense, decide that it's only fair that this charge should be borne by owners in equal shares, despite the fact that they don't have equal PQs, because that seems right to them in the circumstances. And very often this sort of matter presents as a single unusual expense. For example, we decide we're going to install water meters, and quite clearly the amount spent in respect of each unit is exactly the same, and that triggers the suggestion that the expenses be recovered on a pro rata basis. But as I say, sometimes there's not a lot of thought given to the issue. The deviation from the participation quota just seems fair in the circumstances. However, it is important to realize, and I think to emphasize, that the default position in regard to the collection of any costs, any levies in a sectional title scheme for any type of expense is provided for in section 32(3)(c) of the Sectional Titles Act. And it reads, subject to the provisions of subsection 4, which I'll deal with in a second, the quota of the section shall determine the proportion in which the owner of the section shall make contributions. So when no other arrangement has been made, either by the developer or the body corporate, the situation is that levies must be collected in accordance with participation quotas. Those allocated in terms of the last page of the sectional plan to the sections in the scheme. The only way in which this default situation can be changed is for all owners, in fact it's not all owners, it's a special resolution, but in effect it's all owners, agree to a new basis for the collection of levies, and a rule is made to reflect this new arrangement. And bear in mind, if you do this sort of thing, if you do consciously address the issue and want to do it, you don't have to do it for all types of expenses. It's possible to make a rule that only applies to a particular type of expense, perhaps a recurring one, or a one-off expense, such as the example I gave you. Section 32(4) of the Act says that such a change, a modification of the effect of the participation quotas in this regard, can be made by providing that the members of the body corporate by special resolution make rules under section 35 in terms of which the liability of any owner of a section to make contributions is modified. But there's a sting in the tail. Where an owner is adversely affected by such a decision of the body corporate, his written consent must be obtained. So as I indicated, it's not just as simple as an ordinary special resolution. 3/4 of the people who turn up at the meeting can take the resolution. One assumes that the people who would object would be those who were adversely affected. But we need to look at this issue again carefully. In the circumstances, the body corporate really only has two options. It can continue to collect levies in accordance with the participation quotas of the sections, which it must do unless it's made another arrangement as I described, or it can make a rule creating perhaps a notional participation quota, either for all expenses or for particular expenses. While the process for the change is a special resolution, the proviso requiring every owner who's adversely affected must consent in writing means that it's not as simple as an ordinary special resolution. It's not necessarily easy to achieve, but there is case law to the effect that a person cannot refuse consent merely because the rule requires them to pay more money. If the effect of the rule is, as considered by the court, considered to be fair, and then the court today, and in due course an adjudicator under the Community Scheme Ombuds Service Act also, will be able to consider that the special resolution should be taken and is taken, given that the objector's consent was not required because they weren't adversely affected. In circumstances where there is sufficient consensus to achieve a special resolution to modify the effect of the participation quota in regard to all or a class of expenses, I suggest that trustees should go and get professional advice, both to settle the exact wording of the rule they put about and also to establish whether in fact anybody will be adversely affected. Thank you for joining me in this Paddocks Club video tutorial, and if you have any questions on this issue, please let's deal with them in the discussion forum.